Hello everyone, it's Harry Sherrod again. This is the second of my videos in my Employment Law Foundation course. Now, in my first video I talked about ordinary unfair dismissal, and I explained that in normal circumstances there is a 2-year qualifying period before an individual could claim unfair dismissal. But I mentioned that there are some categories of automatic unfair dismissal, and why employers need to be aware of those is because the 2-year service requirement does not apply. And if an employee is dismissed for one of these reasons, even on the first day of employment, they potentially could claim unfair dismissal. So there is a longer list. I'm just giving you 4 examples there. So whistleblowing, trade union, health and safety, and pregnancy, a fairly obvious one there. So let me give you an example of how that could play itself out in the workplace. So a new starter comes in, joins an organisation, and he's a trade union activist. Tries to recruit people to join the trade union. Employer doesn't like that, thinks potentially this is going to be a problematic situation. The employer thinks, well, he's been here a lot less than 2 years, he can't claim unfair dismissal, so we'll just fail him in his probationary period. Sorry, your performance wasn't up to scratch, we're terminating your employment on the grounds of a probationary failure. So on the face of it, that's what the letter says, but if the employee brings a claim and manages to persuade an employment tribunal that in reality, the employer was motivated by his trade union or opposition to his trade union activities, then it's game over for the employer. The employee automatically wins that case. Everything I said in the last video about fair and reasonable and so forth, none of that applies, because if that was the reason, the employee wins the case. So as I said in my first video, generally speaking, it is the 2-year qualifying rule. But employers need to be aware if an employee has blown the whistle, complained about some legal situation in the organisation, there have been trade union activists, they've complained about health and safety in the workplace, and that of course could be relevant in the coronavirus situation, or a person dismissed because of their pregnancy. So there is a longer list, as I say, so employers do need to be aware of that list when they're contemplating the termination of an employee's employment, and make sure that none of those automatic reasons would be the true motivation behind a dismissal. So that's the end of my second video. In my third video, I'm going to be looking at discrimination.